Hey, hi, Krystal.
Hi, can you hear me?
I can hear you.
Fantastic.
Awesome. Sounds good. Thanks, Krystal, for joining. We'll give it a minute. I know I see everyone's joining. It's good. Give it 1 minute. How's your day?
Good so far. Excited to have this conversation today. How about you?
Oh, me too. I know there's been so much going on over the last like 3 to 4 days. Yeah, it's good to just be on the call and address like those questions. I see like what we have a lot of interest on this one. Yeah, I'm just expecting like to have like more than 100 participants join this call.
That's exciting.
Okay. Once again, thanks for taking the request to join the call, Crystal. Yeah, it's good. It's always good to have like an attorney presence and go through like a lot of questions because yeah, because of many things, right? Every day, like there's so much things going on, especially as I said right over the last week. It's just to understand the nuances and just talking to the nuances and getting like everyone understand would always be awesome.
Absolutely. Yeah, it is definitely an evolving area. And so happy to be here to share any insights that I can to help kind of answer the unknowns. Unfortunately, there are still some unknowns, but
Exactly, exactly. Yeah, I know, right? There's like when you look at the social media, there's a lot of things going on. And there have been like some posts, like with some people, like it's contradictory. So this is like always a good time to just talk about them. Okay, so we can get started. We're 2 minutes in, just for the sake of time. I'm going to share my screen. Yes. Crystal, can you see my screen?
yes, I can.
Yeah. Hey, hi everyone. First of all, thanks for joining the call. And we do have a surprise. I know we did not mention in the marketing material that Crystal would be here, but yeah, again, thanks again, Crystal, for taking the request, joining the call. And one quick thing to everyone: can you all see us and hear us? Like, if yes, like, can you add like yes in the Q&A section, please? Okay, so I see a couple, yeah, mentioned yes. So thanks, everyone. Okay, so thanks everyone for joining the call. And we are here to talk about like many things. We're here to talk about like the H-1B changes, like what's exactly is going on. And the goal is like first we thought like it's just going to be EB1A, but as H-1B we're talking about like it's always important to talk about like other alternative path as well, which is going to be O1A. A quick introduction about me. I'm Raghu Reddy Suram. I'm a CEO and founder at like EB1A Experts. And Krystal Kirst is like an attorney at Boundless. She has over like a decade of experience, like working in the immigration space. She worked at like companies called EIG, which is one of like my I used to work for Salesforce and I worked like very closely with EIG. So since then, like it's been my favorite company as well. So as BAL as well. Now, Boundless, as you know, right, we have a huge partnership with Boundless for the last couple of years. We've been, I mean, getting like a lot of assistance from them. She's worked at like all the like really good like immigration firms. And when we can add like a small pointer like later as well, Crystal. I would like to talk about like the firms as well. So we, Chris, as I can say, Crystal is representing Boundless. I'm representing EB1A Experts today. Boundless is, yeah, I mean, Boundless has helped like over like 100,000 visa holders like over the last like 7 to 8 years. Especially on the EB1A front, all the attorneys at Boundless, like included, have handled like more than like 1,000 cases. It was 1,000 cases to be honest, like for 3, 4 months ago. Now the number would have like changed. It has been like much more. Boundless, as I'm working very closely with them, I've seen like how much they can actually leverage technology to help like in the EB1A space, in the 1A space, like in every space as well. There's been like a lot of AI and a lot of like knowledge which has been gathered and it has been actually used in order to make sure like to improve the success rate of like the petitions. And EB1A experts, as you know, we are helping. I mean, the goal is to help like folks with like EB1A, but since then, like we have been also helping like O1A and EB2NAW as well, which kind of like works in the similar space, although there are nuances which are different as well. We have been helping like we have been getting hundreds of approvals to be precise, like it's around like 210 approvals so far. We have a slide to discuss about that. We've been helping tech and non-tech professionals as well. One quick thing, so chat is like disabled for you, but Q&A is like enabled for you. As we go through the deck, please do add like your questions in a Q&A, and we'll take time like in between the whole presentation and talk through it. So over to you, Chris.
Fantastic. So we'll go ahead and start this conversation with kind of the catalyst behind why we're here today, which is due to the recent announcements that the government has made about current and prospective changes to the H-1B program. So I'm just going to really review these at a very high level, kind of explain to you what we know and what we don't know, and why really now is the best time to consider alternative options, including the O1 and the EB1 processes. So I'm sure you've all heard there was the presidential proclamation issued on Friday, which introduced this new $100,000 fee attached to H-1B petitions. There was also a lesser known update on the Department of Labor called the Project Firewall, which is their initiative to increase compliance investigations relating H-1B employment. And then lastly, we had the more recent release of DHS's wage-based H-1B lottery selection proposed rule, which essentially incentivizes employers to, pay employees more, which would give them a higher selection rate at the H-1B cap lottery. And so I'd really like to spend some more time kind of discussing the presidential proclamation because that has created most of the confusion and the panic that we had seen over the weekend. Unfortunately, there is still a lot that we don't know, and what I anticipate will be kind of cleared up in the coming weeks as far as like what the concrete impact would be. But what we do know, and it has been clarified by several different guidances from the government, is that any H-1B petition that was filed prior to the effective date of this proclamation on essentially midnight of the 21st is not impacted by this fee. That includes pending applications as well as approved petitions. This also, the State Department has clarified, should not impact ability to travel, utilizing an existing H-1B visa stamp, or applying for a new one. USCIS has also come out to confirm that this does not impact H-1B renewal petitions, and that really the target here is new H-1B petitions. There is still a lack of clarity on the definition of what is considered new because there's lots of nuances when it comes to an H-1B petition. So it's unclear if a change of employer or an amendment petition would be impacted. We have seen USCIS receipt those petitions without the additional fee, but we haven't yet seen if there's an RFE that's going to be issued. We do anticipate that the bulk of this is intended to impact newly selected H-1B cap or cap exempt H-1B petitions, but that is something that hopefully will be clarified. And my recommendation, because impact is really specific and a lot of the guidance is still unknown, if you have any questions about your individual situation, please do discuss with your employer if you're going through some sort of petition filing currently after this effective date, and also if you have any travel plans, just to make sure that your situation has been reviewed and that you have some degree of confidence in proceeding with your intended plans. And so where we see that this is going to continue to add challenges, quite frankly, in the entire H-1B program, these policies will likely increase employers' costs across the board when you're looking at compliance, the H-1B cap lottery, prevailing wage guidance, and then also this $100,000 fee. And so that could have an impact on employers' willingness to sponsor the H-1B in the future. And so that's something that we have to monitor. Also, potential changes to that prevailing wage requirement could make it challenging. And then mostly there's always been, for the last decade, the H-1B cap lottery has been oversubscribed. And so this only adds to the unpredictability of whether or not someone's going to be selected, which for, the audience here, that removes control over your ability to kind of dictate how your profession will proceed here in the United States. And so with that, we do have some options that we would like to explore and discuss to make sure that you're all aware of what this means for you. All right, so we'll start with the EB1A petition. So this is one of the highest classification employment-based green cards here in the United States. It is also the fastest path to permanent residency. This is alongside the EB1B and the EB1C, but those classifications are, subject to employer sponsorship. And so the huge benefit of this process is that it bypasses the very lengthy perm certification, and it essentially is a much quicker route to that green card process. And the eligibility, you do have to show that you meet at least 3 out of the enumerated 10 criteria to show that you are an expert in your respective field. Yep. And so then here, so why would you choose the EB1A? Why is it something that you should consider? And, kind of echoing what we've just discussed, this is the fastest track. So in 2 main ways, not only is it the highest classification, so based on country of birth, looking at priority dates, it's going to be the fastest route, comparatively speaking, to EB2 and EB3. And then again, it does bypass this very lengthy perm process, which right now, the projected timelines for that can exceed 2 years. And quite frankly, most people don't have 2 years to wait around to see if a singular process is successful. There is also premium processing available for the EB1A classification, which then gives you another degree of control over the timeline of your process so that you can choose, to pay this additional fee to get an expedited adjudicated review of your EB1 petition. You can also include your dependents in the subsequent filing for the green card process. So this is not only a benefit to you individually, but also for your family members. Being very mindful, especially for children, because they do age out, generally speaking, at the age of 21. So this can give you an expedited route if you do have a child who's a little bit older and you want to make sure that they're protected under this process. And then really importantly, and kind of one of the main reasons why we wanted to raise this to your attention is that self-sponsorship is available. You do not need a job offer to be eligible for the EB1A classification. You certainly can still have an employer sponsor you, but that's a huge benefit because it's the only employment-based classification at this level and at this speed that grants that benefit.
Thanks, Chris. Let's go.
All right. And then so it's also important in this conversation to raise the O1A, especially because that gives you a quicker route to, a temporary work visa that's kind of, aligned with what an H-1B would necessarily provide to you. And what is really important here and why this goes hand in hand with the EB1A classification is that the criteria largely overlaps. And so qualifying for one may indicate qualifications for the other. And so similarly speaking, O1A is reserved for individuals who are at the top of their field in the fields of sciences, education, business, or athletics. Now on the O1A side, which does differ from the EB1A side, employer sponsorship is required. However, it's not as tightly required as the H-1B is. And so just to briefly explain what that means, traditionally you can have your W-2 employer sponsor you for the O1, but if you founded your own company, you can also have that company sponsor you under certain set of requirements. And then also there's an additional flexibility under what is called the O1 agent petition, in which if you are in traditionally self-employed or freelance type of job, essentially you can have some sort of US agent here sponsor you so that you don't necessarily have to have that strict job offer like you would for the H-1B. Similarly speaking, you do have to show your sustained national or international acclaim in your field, meeting 3 in this case only out of 8 criteria. And that includes things like major awards, original contributions to your field, and authorship of scholarly articles. So this can provide a more flexible pathway to have work authorization here in the United States, which then hopefully would then translate to eligibility over to the EB1A classification. Okay, and then here, some of these main benefits, really important is that there's no lottery limitation. You're not subject to having to go through this process that is only available one time a year, and it's limited by a statutory quota. If you qualify, you do get to take benefit of the O1 status immediately. Similarly, there is also premium processing available so that you can kind of have that control in that processing time and not be subject to very long delays. For instance, in the H-1B cap world, you're filing a petition around April. You don't have the employment until October. And again, this is a stepping stone to the EB1A. And I do also want to just point out here that while the criteria do largely overlap, In comparison, the scrutiny for O1A is significantly lower from USCIS because it is a non-immigrant classification. Currently, based off of USCIS's posted data points, their approval rates are quite high, in excess of 90%, and their RFE rate is fairly low, around 18%. So if you're working towards EB1A classification, you've met some of, the minimum 3 criteria, maybe you can go ahead and would be eligible for the O1A while you continue to build on that EB1A eligibility.
Thanks, Krystal. Okay, sounds good. Yeah, Krystal, do you want me to talk through it or do you want to go through it?
Either way, I'm fine.
Sure, sounds good. Yeah, go through it, Krystal. I'll add a
Okay.
few points as well. But yeah, go through it.
Okay, fantastic. So we've provided here just a comparison chart high level so that you can kind of see what the benefits are of these alternative options to the H-1B. So again, the timeline, the H-1B is, stagnated to that once a year lottery to get into it. Now with all of these additional changes, that's going to be considerably more harder to do. Also with H-1B, there's a limitation on how many years you can hold H-1B status, notwithstanding, having an I-140 in process. Whereas the O1, you don't have that limitation. You have an initial 3 years and you can renew indefinitely, which at some point then you would convert over to the EB1A and become a lawful permanent resident. Also looking at the cost, there's much more higher reoccurring costs for the H-1B status, comparatively speaking, whereas, EB1A, it's really just this one-time fee that you're paying. Looking at, building into your profile, all of the efforts that go into that, filing a very strong petition with USCIS, securing that approval because it's not subject to a particular job offer that remains eligible for purposes of the green card, provided you continue working within your field. Similarly, speaking with the O1A, it's the filing cost. And then the idea for many applicants that I've worked with, they'll start in the O1A. Generally speaking, they don't make it to the next extension because they have worked so hard on their eligibility towards EB1A that they end up moving through the green card process quite quickly. Looking at the freedom that you have and the options, H-1B is pretty much locked down to your specialty occupation for this particular employer, whereas you have a lot more flexibility in the EB1A, it being self-sponsored. While O1A is still employer dependent, as we discussed, there's some other flexibilities available, not currently available under the H-1B status. And also the regulations and requirements for amendments, comparatively speaking to the H-1B, are much looser. So you don't need to have as many frequent O1A amendments, comparatively speaking. It's not subject to a particular work location, for instance. And so you can save on that and be able to kind of move a little bit more freely within your career. Looking at the stability, I just think that the rate of the changes that we saw in such a short period of time is a clear indication of what the current administration plans to do, not only now, but continuing through this administration. Kind of puts the reliability of the H-1B program at risk, generally speaking. Whereas, EB1A, it leads to that permanent residency. Once you have that, you have the permanent ability to work and live in the United States. And so you're not kind of restricted in constant filings and changes after the fact. And then similarly speaking with the O1A, because we're not seeing, policy changes directed to this visa classification, I would consider it to be a lot more stable than the H-1B program currently.
Awesome. Thanks, Krystal. So I know we're talking about like the comparison chart, like a lot of the benefits as well. I would just want to quickly mention a quick disclaimer. So all the information we're sharing is like information purposes only. If you have, I'm seeing like some questions more custom to your profile. I would request you to set up a call. I'll send you the link in a second. Where to set up the call, try to understand for it. Of course, like if you're working with a company, you always like have your employer attorney, like whom you can discuss like about the different options as well. Of course, like there's a lot of benefits, pros and cons of each of the opportunity as well. I know we talking about like the 4 different things, but Krystal mentioned like many of the different benefits of O1A versus H1B versus EB1A as well. Any questions on that, please add in the Q&A section. We'll go through it. Thanks, Krystal. Okay, so let's talk into some common myths. These are like I would say like top 4, like or top 5 myths, like which I see like from our customers. where they say like PhD, masters, or bachelors like are really, really important, like in order to qualify for EB1A or O1A. To be honest, when we read through them, like it's clearly not mentioned. The education is like the importance of education. We'll look into the next slide where like what exactly the eligibility, what are the different criteria. So the important thing when you look at the petition or when you look at the work is the impact of the work which is done and how do you meet the criteria is like more important than like you having an specific type of education. The other common question which I always say is like startup, like startups to enhance your eligibility. This has been a common question on EB1A, and this has been a big myth like on O1A as well. Everyone, like especially in the last month, I've been talking to, they're saying that is O1A only for founders. Can like tech professions do apply for it? To be honest, again, right, we applied O1A for a lot of tech professions so far, so there's no question on that. And when you are starting a company, the important thing is how what product you're starting and how original it is, like how people are using, how much revenue is generating. So that's the original contribution, which would actually help like with the whole petition. And irrespective of your startup, like working for a company, then like if your thought process and everything is original, that actually meets the original contribution criteria, which is one of the criteria for EB1A and O1A, which we'll look into the next slide. And the other common question, which I'm also seeing like in the questions, is like how many criteria do I have to meet? For EB1 and O1, the eligibility is like to meet the two buckets of eligibility. One is like the criteria eligibility, which is like 3 out of like how many criteria listed, and then there is final merits. So both needs to be accepted to be eligible. But like what is it? The common criteria which I've seen among like our clients has been like around like somewhere between like 5 to 6 criteria. Although, again, this is kind of varies from person to person as well, attorney to attorney as well. There could be like 3 criteria if you're meeting their in-depth criteria, then that should be okay as well. But there's a lot of different things into the criteria as well. So every case could be different, but 5 to 6 criteria is something which we always recommend to meet to have like more stronger overall profile. And then this is a very less myth these days because there's a lot of information available that you need to be a manager to eligible for EB1A or O1A. The reason this myth has been coming is I mean, especially compared to in the last decade, there have been many EB1C approvals. So, an EB1C is like usually a manager. So this question has been coming very often. In our client base, like when you look at it, like 90% of like the applicants are actually ICs. 90% of the approvals have been ICs, including me as well. So with that, let's quickly talk about like the different criteria. So these are like the 10 criteria. What you see, these are all like EB1A criteria, and number 7, which is like the artistic exhibitions and commercial success. These two are actually not part of like O1A. And I don't want to go in depth here, but like what we see, most of you folks here, like I assume like you're tech professionals. Tech professionals, the critical role and original contributions are like the two important criteria, and that's where like the theme goes in. And the other criteria, what you see here, like awards, memberships, published material about you, judging, scholarly articles are like the ones which are telling which are like the supporting the story for the critical role and original contribution. Of course, like a disclaimer, this could be a little bit different for different people, but this is what we have been seeing like among the drafts, like which are done by the attorneys. A quick look at like all the criteria here. Like if you look at the awards of excellence, probably might be aware like a lot of different awards like within the companies. And these awards of excellence are the awards of excellence to meet the criteria. They have to be nationally or internationally recognized and provided by a distinguished organization as well. And distinguished organization, nationally or internationally important, nationally or internationally recognized organizations has been a consistent requirement among different criteria as well. So we have done like 4 webinars dedicated on different criteria, dedicated of what are the type of evidences usually we qualify with multiple attorneys from Boundless. I'm going to share the links like for like those webinars were uploaded on our YouTube channel. Like what so you can go through it and try to understand what level of depth of the evidences are required for EB1A and O1A as well. And any questions you can also add to the Q&A section here as well. Now let's try to understand our approach as in like the EB1A experts and Boundless approach, like what exactly we do in order to like work on different profiles for EB1A and O1A. The most important thing is like we try to evaluate the profile. A customer comes to us, we try to understand like what exactly they have done so far, how is their critical role, how is their original contribution as well, and try to understand like whether this profile is eligible, even actually eligible to work towards EB1A. Then we have a tailored strategy decision, what exactly we need to do over the next 6 months or next 8 months, depending on the plan you choose, what we have to do, a personalized strategy to meet those criteria. Then we collaborate with you, we work with you, we take a lot of different content as well, whatever the content required. Then working along with you, we try to meet like different criteria. And in the process, of course, like we work with like Boundless. And the fourth important step is like the petition preparation and assistance. This is where like we'll be introduced to the attorney. Attorney evaluates like the depth of the evidences as well, and try to understand like what are all the evidences which should include in the petition, what tells a better story, what doesn't. Accordingly, they strategize and then like work with you along and then prepare the whole petition. Of course, I know I mentioned this into the four different categories as well. But when you go through the process, there's like hundreds of different tasks like which actually do come up. There's a lot of content writing, there's a lot of strategizing, there's a lot of deep research which actually goes through it. But at a high level, like there was these are the four different categories of our approach. Now let's look at quickly about the plans which we support. I know this is like the EB1A focus plan. So we have four plans like Elite, Accelerated, Navigator, and Assure Pro is like an add-on among the plans. And depending on your comfort, depending on like the process like you want to go with, these are differently structured. And one important thing which we would like to also add is like for O1A, we have like three plans: Elite, Accelerator, Navigator, and we do offer like 50% refund if like your O1A doesn't go through. Just want to add that specific point there. With that being said, I have a couple of slides when we go through the questions. One slide is like we EB1A experts, we celebrated like 200 approvals this month, and we currently have like above 80% approval rate, like average over the last like 6 to 8 months. Although the adjudication trends have been like changing a little bit here and there, that's what I'd like to point out. And then we have 100% O1A approval rate. We started as like EB1A, then like through the process, like when you get like clients on O1A, when the requirements are O1A, so we were trying to work on them. So we have 100% approval rate on O1A. With that being said, we will go through the questions. So I just want to open this one and then with the question. Okay, Krystal. So one quick question what I have at the beginning is about, you talked about like the amendments and transfers. I do understand like transfers is a language which is actually used a lot, but technically H-1B is not a transfer. It's always a new petition. And you did also mention at the beginning saying that we don't know like that information, and you have submitted some petitions, you're waiting to know like whether they go through and those RFE. Do you know like by when would we know like whether the new petitions, aka transfers, we would know that information about?
Yeah, that should be publicly available certainly within the next 2 to 3 weeks, because many of these cases are filed under premium processing. So we'll know whether or not the case gets approved, or whether or not, we start to see RFEs being issued for this fee. It's also important to call out that as it currently stands, there is no known way for the government to actually collect this fee. It's not anticipated that that is something that has already been figured out. So that's kind of another complexity to the unknowns that we don't know. So our current idea about impact is that it's more so on these initial cap subject cases. And I have seen a couple of questions in the chat about the cap exempt. It will impact cap exempt. That's not excluded from this impact. And so, a new one, maybe it's the very first one that they have. That is an area that is still unknown, but I definitely think that over the next 2 weeks, we will have a very clear answer on that.
Makes sense. Sounds good. Yeah, that's one of the questions which I see here. Then is there any other unknowns apart from like that specific unknown what you mentioned, Krystal? Is there any unknowns like in the whole process right now?
Yeah, certainly there is many unknowns. I think we could talk for hours about how this really plays out, because this process is so nuanced. There's a lot of misunderstanding of the use of the term visa, right? Here, when we say a visa, we're talking a visa at a consulate that you're getting. That's different than the petition that you're filing with USCIS. These proclamations and updates seem to interchangeably use these terms. Similarly, with the H-1B, who is required to necessarily pay this fee? The regulations are very clear that H-1B related fees should be paid by the employer. This doesn't quite fit into that. So, is there an expectation that it's the employer that pays it per fee? Is it something that, it could be passed off to an applicant? We're not totally sure. And then one of the kind of biggest unknowns right now is the impact if you're filing it while out of the country versus in the country. The initial proclamation seemed to be targeting individuals who are outside of the United States to enter with a new H-1B petition, but subsequent guidance from USCIS and CBP seemed to indicate that maybe it's any petition filed after September 21st that is considered quote unquote a new petition would be impacted by this.
Awesome, awesome. Thanks, Krystal. Yeah, I know there's a lot of like unknowns. We'll probably uncover them like as we go through it, like in the next few months. One question came about like the wage levels. How are those wage levels calculated? I'm assuming it's BLS and DOL, like the website data. Apart from that, like, is there any other ways to the ways the wage levels are calculated, Krystal?
Yeah, so this is also, from my perspective as a practitioner in this field, it seems that there's some misunderstanding from the government side in how this works. There is a difference between what an employer is willing to pay for a role in an offered salary versus what is the baseline requirement from prevailing wage. The wage guidance, the levels 1 through 4, is intended to be based off of the experience required for the actual role. The way that this appears to be wanting to be implemented by the government is that it's really just based off of whatever that offered salary is. So there is a nuance in that. So for instance, when filing the labor conditions application in which you choose which level the case falls under, you could choose a level 2 based off of what is actually required for the role, even though the offered salary does meet the level 4. It seems like there would be an incentive for employers that if you meet that wage level 4, that would be the one that you would select on the CAP subject H-1B petition. How that could impact future renewals if you start at a level 4, unknown how USCIS will adjudicate that in the future. I did also see a question in the chat about when we're looking at calculating what is that prevailing wage, what goes into that. It is based purely on base salary. So bonuses, equity, any other type of compensation is not included in that analysis.
Yeah, that's a very good point. I know, like, what is a lot of startups. I'm just thinking out loud, right? Yeah, I've been in Bay Area, moved to Seattle like recently, but Bay Area, like a lot of startups, like try to give like a lesser base salary and higher equity. Now, I'm just thinking out loud that probably like that structuring probably would change like moving forward.
Agreed. And that's also an important thing to kind of call out when we're looking at the area of extraordinary ability and we're looking at what we, generally say high salary. It's not base salary only. We can include things like bonuses and equity grants. And so, there is that additional benefit, particularly for, I think, the tech industry when we're looking at these alternative options, because that is so common, a way for these organizations to set up their compensation schedules.
Exactly, exactly, Kristen. And now, like the other question, I know you addressed this one, but I think I see a couple of questions on O1A eligibility. How, the question's more on like who can sponsor and also like how much is the eligibility. The other question is like, is there any limit? Like, is there any limit? Like, how long would it be valid? And the other question is also like, would it actually cause like any travel issues?
Okay, those are great questions. So let me see if I can remember all of those. So the requirements, similar to the EB1A, is 3 criteria. That's the minimum. Now it's out of a different number. It's 3 out of 8 as opposed to 3 out of 10. But for individuals largely in the tech industry, it's kind of the same criteria that you would use for both. Now the scrutiny threshold is lower though. So when we're looking at EB1A, it is always best to really build on your profile to meet that 5 or 6 criteria criteria to give you that stronger analysis for the final merits determination. When we're looking at the O1A, because the scrutiny is a lot lower, sometimes just meeting the 3 is sufficient for an approval. You've seen that in your approval rates. We're seeing that approval rates with USCIS. We're seeing that approval rates here at Boundless. And so it is, I would say easier to obtain than the EB1A. When we're looking at validity periods, so the initial O1 petition can be granted for up to 3 years. And I do say that specifically because USCIS officers are allowed in their discretion to limit that validity to less than 3 years. And that really pertains more so to the agent-based cases, which I'll explain in a moment. So generally speaking, that initial grant of O1 status is issued for 3 years. Then after that point, you can have 1-year extensions indefinitely. Now, if you wanted to request a new 3-year period, you could do so by essentially kind of changing what you're intending to do on that O1, right? So if you've got a large promotion, you can argue that this is a different role. If you change employers, that would also allow you to get that another 3-year grant. And then when we're looking at how to prove that sponsorship, like I had mentioned, it is much more flexible than the H-1B, where it's very traditional H-1B employment. There is some contracting situations that are allowed, but the scrutiny on those cases is a lot higher. So the 3 main areas is your general employer, your W-2 employer, whoever you're currently working for is willing to sponsor you for the O1. That's, I would say, the most common route. Then if you, kind of are the founder of your own company, you can have that company that you have founded sponsor you for the O1. There, you do still in any in any O1 petition, you do still have to show an employer and an employee relationship, but it's not as stringent as the H-1B requirement. So when we're looking at the founder situation, if you can show that you don't own majority share, if you've got a co-founder who owns 51%, for instance, they've got voting share within the company, or if you do own a majority share, but you have a board of directors with the authority to fire you, some sort of way to show to USCIS that this is not self-employment, that there is actually an employer for the role. It is also important procedurally under that situation because you need to have a petitioner for the actual form, someone but the applicant needs to be able to sign, right? So if that's an HR person, if that's an accounting, if you've got an attorney that you've used to set up your business, all of those individuals can be authorized to sign off on the form. In my experience with this particular area, USCIS, what is most important is that the company is a US-based organization. It has a business FEIN, which is the Federal Employer Identification Number. They don't harp so heavily on the underlying paperwork, right? So it's important that you have all of that in place should there be an RFE questioning employer-employee relationship. But generally speaking, we don't see a lot of pushback on that. There's a lack of guidance from the government, which I always indicate is probably then a lack of internal training guidance for the individual officers. If it's not in a policy manual that it's required, then likely an officer's not going to be looking for it. And then the third area is this agent-based O1. And so there's a couple of different scenarios that this applies in. Most commonly, it is used for individuals who are generally self-employed or freelance, right? So consulting-based work. And you have an agent here in the United States, which can either be a person, a US citizen, or an actual entity where you have an employer agreement with. They're essentially serving as your employer, and they are helping you obtain various work engagements, like statements of work with, essentially a consulting client. Another way that this process works is if you have if you're actually employed by an employer abroad, a foreign employer, because they don't have a presence here, they can't serve as the US petitioner. Instead, they have an agent serve as their representative. And so essentially, it's really just procedural where the employer abroad has an engagement agreement with the US agent to serve as a petitioner for purposes of this individual O1 petition. So that does provide a lot more flexibility than what you would be able to have in the H-1B. Was that all of the O1 related questions? I think I hit them
One
all.
thing, travel related
Oh,
question.
yes, travel. That's a great one. So, travel, generally speaking, so, we've H-1B is dual intent, right? Same thing with L1. There's really no conflict between proceeding with the green card process from start to finish. O1 enjoys what is called quasi-dual intent, meaning when you're at the I-140 stage, there's no impact at all. You can file an EB1 petition, you can travel, you can file for an extension, get the O1 visa, literally no impact. There is firm government guidance that there's no concern there. Uh, Impact to travel really is only predicated when you're getting to the I-45 filing, because unfortunately it doesn't have the full dual intent. There's really no concern from the government side that you're maintaining O1 status and proceeding with the green card. So it's not the same as a single intent visa like the F1, TN, E3 similarly, but you can't unfortunately travel pursuant to the O1 when you have a pending I-45. So you do have to wait for that underlying advance parole document, which you can apply along with the I-45 to be granted. And so right now we're seeing long processing times. I really, quite frankly, don't anticipate that those would decrease. And so for many O1 applicants that I've worked with who are going through the green card process, because, if you're an executive or someone who has to do a lot of business travel, a lot of times they'll opt to actually complete the green card process outside of the United States. That is called the consular immigrant visa processing. If you choose that route, so you wouldn't file an I-45 here, it's a separate form. It's called the DS-260, kind of similar to the DS-160, and that is a whole process that you complete abroad. If that's the process that you're going through, then you can continuously travel in and out of the country in O1 status while you're completing that process. It's just important to note that to complete that process, you do have to physically exit, complete the visa appointment at the consulate abroad, and then re-enter the United States as a lawful permanent resident. So if you're interested in O1 and you're getting to the stage, your priority date would be current for green card application. I would encourage that you discuss with legal representation what are the pros and cons of doing the adjustment of status here in the United States versus this consular process abroad. But there is an option.
Awesome. So that's good. Yeah, thanks the detailed answer there, Krystal. One thing is, I would just like to add as well, right? So on O1A, like what is it? It just works like the travel works as like H-1B, right? You just go, you get the stamp, like as long as the stamp, like you can do that. The other set of questions is like, I have an O1A, if I have an O1A or if I have an EB2A like can I apply for EB1A? Would that add like any value to EB1A? And which goes first? Should I go with EB1A first and then O1 or vice versa? I can actually take the later second question. We have clients who have done both. We have clients who have done EB2A first and then went for EB1A. O1A first and then EB1A and EB1A and then O1A as well. So we haven't seen any issues with any of those cases. To be honest, like what's there is overlap of like the criteria. So then like once you work on one thing, definitely it would add an advantage. But I'm assuming, Krystal, that like having one doesn't necessarily guarantee like the other visa or like the I-140 type.
That is absolutely correct. Yeah. So I completely agree with that. I've seen that on my side. I've done it in a myriad of different ways, really just dependent on what the individual's needs are at the time that they're applying for these various statuses and classifications. So in the past, maybe 10 years ago, USCIS would kind of heavily weigh if somebody was in O1 status at the time that they're applying for EB1. We don't see that anymore. In fact, the current administration had updated the policy guidance on that by being in O1 status, having previously been granted that status, does not necessarily indicate that someone is then eligible for the EB1A process. Now, if you are working on building your profile towards EB1A, and for one reason or another, if you're in F1 status and you haven't made it into the selection or you don't have an employer willing to sponsor you, that would probably be the situation in which you would want to consider the O1A, just because if you're working towards the EB1A, the chances are of getting that approved first is probably higher just because the scrutiny is lower.
Awesome question. The one as a couple of questions with now H1B would have like 100K fee. Would you see like O1A, like what is it going? I mean, would you see like O1A applications going up? I can probably take that question. So last year, the number of O1A applications have been around like 24, 25K, and they have been steadily going up, but they did not go up like by a lot as like EB1A developer, like EB1A petitions. But in the last week or in the last like few days, we definitely have seen like number of O1A requests have gone up, which technically means that like we would probably select number of O1A applications would go up as well. One important way to track this thing, so USCIS like every quarter, like what they do is like they release the data, how many applications going in for for every type of visa. So when that data comes out, like probably for the next quarter, like we'll publish that data over LinkedIn. But my assumption is like the O1A number of applicants for O1A is gonna go up because the only other like real alternative, which I think for H-1B, at least like for the skilled professionals for H-1B is like O1A at the moment.
Yep, and I would agree with that. And so that is something that we would definitely will monitor. And so like, keep an eye out for any updates on that, just because it does remind me of kind of the influx that we saw on the NIW side, particularly following a lot of the tech layoffs. Perm became a little bit untenable with the layoff provision. And so many employers switched over to the NIW. There was a huge influx, a crazy increase in those filings, which traditionally we hadn't seen. That was largely due to the fact that premium processing finally became an option for that visa classification, in which the regular processing took just as long as perm. So we did see that, and what I will just kind of call out for everyone to take note of is that we did then see USCIS change their adjudication standards. It's a little bit different with NIW because that's purely discretional. You can have a very strong case and there's really no need or you can't compel USCIS to approve it. O1 thankfully still has very defined guidance and guidelines that officers have to follow. So it is possible that we could see an increase in that scrutiny, but again, it certainly will never be more scrutinized than the EB1A. So if that remains an option to you, O1 would also remain an option to you.
Awesome. Awesome. Thanks, Kristen. The other set of questions, what I say is on the eligibility, like can I be a tech, non-tech, construction management, and also the questions about like years of experience. Should I actually try for like O1A? Would you want to talk about that as well, Kristen?
Yeah, absolutely. So I have, I've had this unique experience of being able to work in extraordinary abilities for most of my career, and so I've worked with individuals in a variety of different industries. We are limited to kind of like the big arching areas, but if you're creative enough, you can find someone's expertise falls under whether it's sciences, businesses, arts, any of those enumerated larger fields. And so that generally, I wouldn't say that there's a particular limit to it. When you're looking at, there does need to be some sort of prospective benefit to the United States, but anyone who's at that level in their career is adding benefit to the U.S., whether it's economic or some other policy related area. So there is certainly, I wouldn't say is a limitation on there. Years of experience, there's also not a limitation. For both areas, there is a requirement to show what is considered sustained claim, but USCIS guidance is very clear that there's not a prescribed time limit on that. You can have someone, and I have dealt with individuals who coming out of like a PhD program, they found a company and they're eligible for both O1 and EB1 within 1 year post-grad. So it's really dependent on how strong the individual criteria are. And we discussed earlier, there is absolutely no educational requirement for either of these classifications. You do tend to see a higher rate of PhD graduates, qualifying under these areas. And that's more so just because the nature of the work that's required to get there, the authorship of scholarly articles, doing peer review becomes a little bit more attainable, speaking engagements, that's just generally part of that route. But by doing that in industry, you can also qualify. So I wouldn't limit yourself on saying, oh, I've only done this for a couple of years, I'm not an expert. I have generally found that those who are most humble are generally those who are most qualified. So if you think that you qualify, I do think that it's worth it to at least check out your eligibility.
Thanks, Kristen. A couple of there have been like a lot of like custom questions or personalized questions in the chat. I don't think like we can take those things because we require like a lot of data to answer it. So I have added a link like in the chat, like which goes to like our team where you can go through that. and set up a call. The team probably will answer the questions to the extent we know, looking at the evidences. But if there's anything which you require from Boundless, we'll go to them as well and present you the answer. And I see there's a lot of couple of questions here where the question is like NIW, now the approval rate has gone down. And EB1A also, like what's the saying, like the approval rate is actually going down. With O1A, when you see like the more number of petitions, do you anticipate like the approval rate would actually go down? The current approval rate, I can again probably take some part of that question. The current approval rate, like for O1A, or like the to the extent we know, is around like 95%, which is amazing. And when I seen like based on my knowledge about like the last 3 to 4 years, like of different regular visas, what I see is like when the number of applications do go up, like definitely there is a drop of like approval rate. But considering like the 95% approval rate for O1A, even if it drops like a few percentage points, it's like I think like it's a great alternative compared to H-1B, and it's a very healthy approval rate. That's my opinion. What's your take on that, Krystal?
Yeah, to add to that, I think, we do see differing approval rates. They do change over time. But what I always remind applicants when they're looking at this data point, while it's certainly informative and it's something that we want to be aware of, I think, on the O1 side, I think it indicates that if you qualify, likely your case will get approved without an issue. If we start to see that approval rate decline as number of petitions increase, it doesn't necessarily mean that the scrutiny overall has increased. It just may mean that people, uh, you know, who have no other option are going to give this a shot. So they may, be very underqualifying, comparatively speaking, to the general O1 population, but because they're out of options, they're just going to give this a shot. So I wouldn't say that that is necessarily a one-for-one on scrutiny, and that's why, we here at Boundless, we monitor this like a hawk. I personally watch every single notice that comes into our office so that I'm aware in real time on any piece of evidence. What is the strength of that? How can I argue it to convince USCIS, knowing other areas in ways in which they've tried to push back? How can I make a case tolerant to kind of these changes in adjudication trends? So it's an important, metric to measure, but it's not necessarily in and of itself indicating that it's harder to get one approved.
Awesome, Kristen. I think we covered like most of the questions except like the personalized questions. Just for that, like just please use the link in the chat to set up the call. Any closing thoughts, Kristen?
I first just want to thank you for the opportunity to kind of have this conversation with this large audience. I think this is a very important area of discussion currently, and this is an area that a lot of people don't realize exists and don't realize that they probably already qualify for. So I just want to thank you all for your time here today, and again, just encourage that if you are interested in this, it is worth getting your credentials reviewed.
Awesome. Thanks, Crystal. I would like to add like one point here is like over the last couple of days, I've been talking to like a couple of like my friends who have startups. And I did talk to them like a month, 2 months ago, like saying that, hey, why don't you consider O1A? Their option was like, hey, we have H-1B. Like, what is it? There are a lot of H-1B people in the country. And so they were going for H-1B. And of course, like H-1B is like the lottery, but now they have changed their opinion. They have changed their opinion. They put it on LinkedIn. They changed an opinion, and we're going to see many employers change their opinion on O1 as well. Consider like more number of like their employees actually do apply for O1A. So that's a trend which we're seeing. But yeah, talking about that, like thanks, Crystal. I know it's a last minute reach out, but yeah, thanks for accommodating time and helping everyone here. Thanks everyone for joining, and we will upload this webinar like probably like a week to 2 weeks from now, like on our YouTube channel, and we'll send you a note as well when it's uploaded. Thanks, Kristen. Thanks everyone.
Thank you, everyone. Bye-bye.